The United States has introduced a sweeping new immigration directive that allows visa and green card officers to deny applications based on pre-existing chronic health conditions, dramatically expanding the criteria for who may be considered a public charge. The policy marks one of the most aggressive steps yet in President Donald Trump's ongoing immigration crackdown. According to reports, the guidance was circulated by the U.S. Department of State to American embassies and consulates across the globe. A cable sent to visa officers directs them to flag any applicant whose medical condition could lead to high long-term healthcare costs, described as hundreds of thousands of dollars worth of care. The memo lists a wide range of chronic illnesses, cardiovascular diseases, respiratory diseases, cancers, diabetes, metabolic and neurological disorders, and mental health conditions as examples of issues that should be highlighted. But the department makes it clear that the list is not exhaustive. In fact, officers are specifically instructed to consider obesity as a risk factor, noting that it can lead to cost-intensive complications such as asthma, sleep apnea, and high blood pressure. Why the rule is being imposed? According to the administration, chronic illnesses are potential indicators that an applicant may become a future financial burden on the U.S. healthcare and welfare system. The policy is framed as a stricter enforcement of the century-old public charge rule, which historically barred immigrants likely to rely primarily on government assistance. However, past health screenings focused largely on communicable diseases such as tuberculosis, not chronic conditions that millions of people worldwide live with and manage. How far does the rule go? The guidance technically applies to all visa categories, including tourist visas, B1/B2, and student visas, F1. It remains unclear how broadly it will be enforced for temporary travelers. Early indications suggest it will be used most aggressively against those applying for permanent residency. Immigration experts warn the directive gives enormous discretion to consular officers without medical expertise, allowing them to make subjective judgments on an applicant's future health costs, despite the fact that visa forms do not require applicants to disclose detailed medical histories. Advocates say the policy could significantly reduce legal immigration, particularly affecting older applicants and individuals with common chronic illnesses that pose no barrier to work or self-support. This effectively ties immigration status to perfect health, one advocate noted, criticizing the shift as punitive, discriminatory, and medically uninformed. As the U.S. tightens its screens, concerns are mounting that millions could be excluded from immigrating not for security reasons, but because of manageable, widespread medical conditions.